Hi, Lee Phillips again. I want to talk about what I'm going to call a survivorship requirement in a trust or a will. It's basically a provision, and you need to think and see if you've got one, because if you don't have one, your estate may be going through probate twice, actually, or it's going to end up going where you don't want it to go. What happens is you put a provision in the will or the trust that says that your son is going to inherit or be the beneficiary, and the trust or the assets will be distributed to him. But look at what happens if he dies with you in the automobile accident, or 10 minutes later on the way to the hospital. You die outright, he dies 10 minutes later. What happens is the property that you were going to give him or have him inherit or be the beneficiary of, if it's a trust, it's a beneficiary. If it's a will, it's an decedent or an inheritance. But it goes from you to him, but then he dies 10 minutes later. So if you've just got a will, everything will have to be probated in your estate. Then the court will direct that it goes to him, but he's dead, so it goes to his estate, and it will be probated again in his estate. And normally in your will or your trust, you're going to say, if my son does not survive me, then it goes to my brothers and sisters, or it goes to his kids, or it goes someplace else. And without the survivorship provision, it would go from him, or from you to him, to wherever his estate or his will or his trust says it's going to go, and that may not be what you really wanted. So what we do is we put in the trust or the will language which talks about, and by the way, if you want the language to see if it's in your trust or to put it in your trust or in your will, email me at info at legalese, Legalees. It's a pun on my name. Legalese, but there's only one L in the middle. Info at Legalese, and I will send you language for the trust and language for the will, so that you can either put it in your trust or will, or you can check and see if you have it in your trust or will. But if we put it in that son has to survive by 30 days or 60 days. Now, you don't want to make it too long, because if you make it too long, you may be actually affecting tax things. You could be affecting a lot of stuff. So 30, 60 days. 60 days is not uncommon. If he doesn't survive you by 60 days, then we'll say that he actually predeceased you. And your will, your trust, will kick in as if he were already dead and was not going to be the recipient, beneficiary of your assets. So it's important to have the survivorship provision, and I've been doing this for a long time. It's unusual that it kicks in, but when you need it, it's very important. And part of my job as an attorney, and I've been doing this for 40 years now, I guess, part of my job is to pick up those little pieces that, by the way, what if? And you don't want to go overboard on the what ifs, but part of the job is to address all the contingency plans, because we don't know what happens in the end. We don't know exactly what happens. So I won't charge you anything or anything, but if you want this language, just email info at legalese, Legalees.com, and we'll get it to you. And by the way, don't forget to subscribe to the YouTube channel so that we can keep giving you this information. This is actually a question that I got the other day. I appreciate your questions. If you want to have me answer something, please respond by clicking on the response and writing me a note. Anyway, subscribe and we'll get it out to you. The survivorship provisions, the requirements are important. Now, one more thing, actually, before we leave. A number of states, and there's a bunch of them, over half of them, have a provision automatically in their state code which says that the guy has to survive. It's usually 5 days or a week. It's not very long. And if he doesn't, then it kicks in. But if you haven't addressed it, the state could address it for you if you do address it, whatever you put in your will or your trust supersedes whatever the state has. So write it in your stuff and let's get it done.